Hi, my name is Mark Troutman. I'm a litigation attorney with the law firm of Isaac Brandt, Lebman, and Teeter. This is another in my series of video blogs concerning public records law. Today's case that we're going to discuss is another case filed by Brian Bardwell, who is an active public records relator from the Cleveland, Ohio area, who actually maintains a non-profit organization that goes around suing public offices to encourage compliance with public records law statewide. His case is the State of Ohio ex rel. Bardwell v. Cleveland. The site is 126 Ohio State 3rd, 195, or 2010 Ohio 3267, for those that would like to look up the case and read it themselves. Now, the case is a very short case, but its holding and the encouragement and the concurrence of the decision are very important for cases in the future. In Mr. Bardwell's case, he asked for information related to the disclosures that pawnbrokers need to make to local police departments regarding all the merchandise that they bring in or all the merchandise that goes out on a particular day. Without getting into all the details, the law requires that they report it, but they don't require what form the pawnbrokers report this information in. In the city of Cleveland, they use a very, how the court described as antiquated form. They use index cards that the pawnbrokers write the various materials on. Now, Mr. Bardwell requested information related to the disclosures made by the various pawnbrokers, and after what he believed was a substantial delay, he sued Cleveland for failing to organize its records in a way that they could reasonably respond. The city of Cleveland got bogged down in looking through the records because it required various redactions and legal review of some of the information contained in those records. What the court ultimately held was, even though Cleveland used, again, a quote antiquated form of storing these records, that they had not failed to reasonably produce them to Mr. Bardwell. The court focused on the fact that they were made available, and because the statute didn't mandate what form they were in, the city of Cleveland could store them and organize them and produce them in whatever form they saw fit. Now, importantly, the concurrence encouraged the city of Cleveland that when budgetary money becomes available, that Cleveland certainly investigate beginning to use a different form of organization, because so many other forms could exist to assist in this process far beyond that of using 3x5 index cards. What we should take this is where the court isn't yet willing to prescribe what forms of technology should be used in retaining information. The court is at least to the point of encouraging that public offices embrace current technology so that they can make sifting through and organizing their public records so much more efficient for the public. If you have more questions on this case or any other blog, please do not hesitate to contact me. Again, my name is Mark Troutman, and my phone number is 614-221-2121. Thank you.